arrive.
Okay, I might briefly start with my introductions of the speakers, and then we can proceed with the panel. Okay, do you want me to stand back?
For what it's worth, John's name
Okay, I'm going to just stand here. Can everyone hear me?
Yeah, I think
Yes?
my name is here.
No?
Okay.
Thank you, John. Okay, hi, I'm Jackie Lipton. I'm the Associate Dean for Faculty Development and Research at the Law School here. If we could all be present and accounted for. This is the second panel in today's symposium. This one deals with reproductive technologies, availability and consequences. We have three very interesting and expert speakers on these topics, and what I'll do is I'll give a brief introduction to all three of them now, and then I'll just let them speak, and then we'll come back for the Q&A session at the end. The order may be a little different than in your program, or actually it may be the same as in your program. My notes are different. Our first speaker will be Professor John Robertson. He holds the Vinson and Elkins Chair at the University of Texas School of Law. He writes very widely on the intersection of bioethics and the law, and is the author of many books and articles on reproductive rights, genetics, organ transplantation, and human experimentation. Our second speaker will be Andrew Coan. He's an assistant professor at the Wisconsin Law School and has taught also at the University of Michigan School of Law and at Stanford Law School. He writes predominantly on con law issues and is also an op-ed writer who has published in the Los Angeles Times, Christian Science Monitor, Dallas Morning News, San Jose Mercury News, Los Angeles Daily News, and the Legal Times. And our final speaker is Browne A. Lewis, who is an assistant professor at Cleveland Marshall School of Law just down the road. Her research focuses on children's and parents' rights, artificial procreation, and environmental law, and she has written many articles in these areas and has a forthcoming casebook on the inheritance rights of children. Each speaker, as in the last panel, will speak for about 15 minutes, and then hopefully we'll have a lot of time for a Q&A at the end of the panel. So I'll hand it over to Professor Robertson.
Well, good morning, and thank you very much for having me and hosting this conference. I want to especially thank the Law Review and Matt Holy for his flexibility and other efforts in making this possible. The focus here is human rights and international rights and the concept of human dignity that's at the heart of them, how they apply to reproductive issues. That's increasingly a source of discussion in U.S. scholarship, and the idea that there are reproductive rights as a basic human right, as part of human dignity, is I think enriches the whole dialogue about that. The focus has been, to a large extent, on avoiding reproduction, on access to birth control and abortion, and also to some extent on engaging in reproduction as well. And I note the provision from the Cairo conference where women have the right over the number, or there's a right to the number and spacing of one's children, is an example of that. Well, what I'd like to talk about is where assisted reproduction fits into this. If reproduction is a human right, what do we do about people who are infertile and who need assisted reproduction? So I'm going to talk about three areas of assisted reproduction and show how a recognition of the dignity of the infertile couples or individuals who want to use technology to reproduce sometimes conflicts with the dignity of others who aid them, and thus the concept of using international human rights or thinking of rights as encompassing dignity only take us a little way into resolving these issues. So the first one could talk about is basic assisted reproduction, in vitro fertilization, where a woman's ovaries are stimulated, eggs removed, and then eggs are fertilized in vitro, sometimes by a single sperm, intracytoplasmic sperm injection, ICSI, and then later one or more embryos are transferred to the uterus. Well, if you're talking about the right in reproducing, it would seem that ART, IVF should follow as part of that. That enables people to reproduce and have kids, often with their own gametes. So you'd think that protecting access to ART, indeed even providing resources to it, to the extent that one is talking about a positive right here to reproductive health, would be part of that as well. And I'm struck, there's a lot of emphasis on how expensive IVF is, that there is a movement for low-cost IVF that doesn't use as many drugs in stimulating the ovaries and gets you a much cheaper version of the process to make that available to people in the developing world here. So ART would seem to fit into that. Now, on the other side, there's been a critique of ART, IVF, from a dignity perspective as well. In the early days of IVF, some very radical feminists, Gina Correa and others, argued against IVF as an imposition on women rather than recognizing their right to reproduce. It was actually viewing them as vessels of reproduction for the sake of men. So there's a critique from the other side. Rather than enhancing or helping women realize their dignity, was actually interfering with it. I think that critique's been overcome. People recognize the importance of IVF for infertile women and couples. And of course, the other critique of IVF has come from the Right to Life movement, who want to stop it because of what it does to embryos. But that would then bring in all the issues of the dignity of embryos and the debates about that. And a final aspect of this, actually it ties in with the right to decide on the number or spacing of children, goes to the number of children one can have, say, at one time. And the octuplet case from California last year, where 8 babies were born from single IVF process, which would strike many people as excessive. How do you reconcile that with the right to control the number and spacing of one's children there? Isn't that some aspect of deciding on the number of children at one time? So there might be a conflict there with interest in limiting the number of twins or high-order multiples. Now, a second area of conflict between human dignity and ART arises with the use of gamete donation and surrogacy. Now, in this case, the person may lack gametes or lack uterine ability, either because there are physical dysfunction in a woman, she's had a hysterectomy, or the reproducer is a man and doesn't have a uterus and needs the help of a surrogate. Well, if you think about reproduction as a human right, essential to human flourishing, does that extend to those persons who need the assistance of a gamete donor or a surrogate for them to have a child for whom they might have some biologic connection but want to have the rearing interests? Does their interest in reproducing their dignity as individuals, does that then encompass using surrogates or using egg donors? Egg donors perform a very useful function for postmenopausal women or others who can bear a child but don't have viable eggs. And yet there's a potential conflict with the interests of the egg donors, who tend to be younger, in the US are paid. They are ostensibly making a free choice, so they may have a liberty interest there, depending on the circumstances here. But we can see how there's some potential for conflict there between the interests of the egg donor and the interest of the woman or man who need the egg donation for their reproduction to occur. Talking about the dignity, talking about human dignity in terms of life or liberty or equality doesn't take us very far in resolving potential conflicts there. And this becomes even clearer when we turn to the case of surrogacy here, which is back on the radar screen with a recent case in New Jersey that I want to talk about. But gestational surrogacy is indeed an interesting focal point about the debate over human dignity, human rights, and ART, because for some couples or women to reproduce, a couple may be able to produce the gametes. The husband can provide the sperm. The wife has ovaries, but lacks a uterus, say due to a prior hysterectomy or other dysfunction. And for that couple to have a child from their gametes, they will need the assistance of a surrogate, a gestational surrogate, who may, of course, is making ostensibly a free choice. She may be paid. Your point about wet nurses is interesting here, how, yes, a willingness to accept wet nurses who are providing lactation after birth. Do they then become part of the family? Do they have rearing rights? Well, we want to say that about gestational surrogates when they want to assert them. Of course, they're involved at a prior stage of the process. Anyway, surrogacy has had an interesting history in this respect because the first major surrogacy case from 1988, the Baby M case in New Jersey, involved a woman who provided both the egg and the gestation. She's artificially inseminated. In that case, there was both the class issues at stake. Mary Beth Whitehead was the wife and already mother of a New Jersey sanitation worker and provided the surrogate services to a couple who I think were both doctors. And she was paid, and then there was a subsequent major battle about rearing rights of the resulting child. She fled to Florida, was eventually captured is the right word, but anyway, the legal process was brought to bear, and the New Jersey Supreme Court ended up holding that, that she was the legal mother despite her agreement to give up all rearing rights and duties at birth, and would have shared custody with the father, Mr. Stern, who was the genetic father, and his wife, Ms. Stern, had no parental rights at all. And that case basically said that surrogacy contracts were not going to be enforced, both on grounds of potential exploitation of women, the surrogates, and out of interest of the child and the needs of the state adoption system. It analogized it very closely to adoption here and found that surrogacy conflicted with that. A few years later in California, in the Johnson v. Calvert case, we had a case of pure gestational surrogacy where Ms. Johnson, the gestational surrogate, had agreed to accept the embryo of the Calverts, would gestate it, and then at birth she would relinquish all her rearing rights and duties, and it would be that of the genetic parents. That happened, but she later sued, and in that case, the Supreme Court held that, that the surrogate had no rights at all, that the gestational mother had given them up via contract, and that contract should be enforced, and it had none of the difficulties that the New Jersey courts found. And so that gave a big boost to gestational surrogacy, became widely practiced, now a mainstay of assisted reproduction for couples in those circumstances, and has special meaning for gay male couples who want to have children, so they'll get an egg donor and a gestational surrogate. Very careful to separate out, to have two women involved here, to fall within the Johnson v. Calvert circumstances. And now, lo and behold, we have a case of all places from New Jersey which presents the issue of a pure gestational surrogate, the Johnson v. Calvert model, now in a New Jersey setting, and many of you may have heard of this case. It's just been settled, decided at the trial court level, and we'll go to the New Jersey Supreme Court to see what they do with it. But it's a perfect example of the conflict here that arises when one uses concepts of human dignity or reproductive rights as a human right, the right to reproduce, of how that doesn't help us with the issue when there's several parties involved. And this has a special salience because of the importance of gestational surrogacy to gay males who want to reproduce. And I just happened to have last week's New Yorker, the article on the Olson boys suit against Proposition 8 in California, has this very moving photograph of a married male couple holding their twins that were inexorably produced with the help of a gestational surrogate and a egg donor. And so if we ask, what does human dignity or reproduction as a human right say about this? Well, it would first of all raise the question whether gay males have a right to reproduce as well, whether respect for their dignity should mean that they should be able to have children. After all, they're married in many states. And if we're going to recognize them as equal participants in the community, their marriage is recognized. Certainly their reproductive rights should be recognized. But for them to reproduce, they will need the help of a gestational surrogate and an egg donor. And so then what do we do when the interests of those persons may later be asserted to say they want to have a role in the rearing process? Saying we should respect contracts is sometimes taken to be, oh, contracts, that's just an expression of power disbalances between two people. We shouldn't be so respectful of them, especially concerning contracts made before the birth of a child. We shouldn't enforce them. But yet, in the case of gay males or infertile couples who need surrogates, it would seem to me, example where at least let's recognize the conflict here and then work our way through resolving it. When we come to work our way through resolving it, my own personal view is that California Supreme Court got it right. We'll see what New Jersey does with that, but when one really gets into it, it seems to be that the reproductive interests, especially if we think of reproduction as a human right, as essential to human dignity, that should take priority, but we'll see how it comes out. Now, I'm running out of time, but I want to just mention a third area where there's potential conflict here. And that's the area of genetic selection of offspring characteristics through pre-implantation genetic diagnosis, carrier screening, or other methods now widely accepted for serious genetic disease or susceptibility conditions in offspring, except from the Right to Life community. There's a recognition that parents can take effort to have healthy offspring rather than unhealthy offspring, and even though the various claims of reproduction as a human right or is essential to dignity don't go steps further into what does that say about control of the characteristics of offspring. It seems to me one can make plausible arguments that something about that should follow. The area that poses the most difficulty here then is non-medical selection of traits, non-medical selection. And the area that is most salient here and the most fraught for human rights consideration is non-medical sex selection, which is now possible with great certainty through pre-implantation genetic diagnosis. A couple can go through an IVF cycle, then screen the embryos for sex, and transfer only those embryos of the desired sex. It's a little onerous, especially on the woman having to go through the cycle, but we now are at the point where there may be a preconception method. The FDA is now has before it the application for a medical device, flow cytometry sperm sorting, which shows a 90% efficacy rate for separating out a female-bearing sperm and an 80% success rate for separating out a male-bearing sperm. And so artificial insemination or even ICSI with IVF could be done only with the male-bearing sperm or the female-bearing sperm. And so the question is, what does the human right to reproduce and dignity in reproduction then say about non-medical selection of offspring characteristics? There's going to be a conflict here. There are going to be winners and losers. Here, sex selection shows where the problem really is because of the tendency in many cultures to prefer males, especially under a one-child policy, to prefer males. Now, using these techniques will avoid abortion of female fetuses and infanticide of females. So one could argue in that sense it's promoting the interests of women. On the other hand, it seems very tied into a sexist, culturalist apparatus that prefers males. So then how about this as a solution? What about using these techniques only to ensure gender variety in the family, only to have a child of the sex opposite of existing children? So if a family has 3 boys and wants to use either the preconception method to have the next child a girl or the pre-implantation genetic diagnosis method to have the next child a girl, why would that hurt the dignity of women or equality of women as a human right if the couple is actually wanting to have a girl here? So is that a way around it as well? Well, I'm out of time, and I could say much more about that, including some apt quotations from Justice Ruth Bader Ginsburg on how the 2 sexes are not fungible. There's variety there, and there is from the VMI case, but I'll leave that for discussion and look forward to further discussion of this. Thanks very much.
So good morning. I'd like to echo the thanks of all of the previous speakers to the Case Western Law School, and especially to the Law Review Editorial Board, and especially to Matt Holy for organizing this event. I'm very pleased to be here. I am not a reproductive health, not a health policy, not a bioethics specialist. I'm primarily a constitutional law specialist, just beginning to think seriously about these issues. So I've learned a lot already this morning, and I look forward to learning more throughout the day. So I would like to use my 15 minutes here to talk about the question whether it would be desirable for courts to extend, for U.S. courts to extend the constitutional right to procreative liberty to technologies, to any or all technologies in assisted reproduction, like the technologies that Professor Robertson just talked about, technologies including preconception, sex selection, in vitro fertilization, pre-implantation, genetic diagnosis, and also potentially to some emerging technologies, which are at this point merely potential possibilities, like somatic nuclear cell transfer cloning and germline genetic engineering technologies, which might allow individuals and couples to exert substantially greater control over the genetic traits, including medical and non-medical traits of their offspring. Now, this is a difficult question, one on which a fair amount of ink has been spilled over the past decade or so. And I should say at the outset that I don't purport to have the answer to this question. But what I hope to show over the next 10 to 12 minutes or so is that nobody else who is writing on this subject very respectfully, has the answer either. And nobody can have the answer without more serious attention, much more serious attention to the questions of institutional competence and institutional choice, which are embedded in this issue. Now, this idea that institutional choice needs to play a central role and that comparative institutional competence ought to play a central role in our thinking about what constitutional rules courts should adopt is a basic point in constitutional analysis, but one that's frequently overlooked and one which has received essentially no attention in the relatively large and rapidly growing literature on the extension, the application of procreative liberty to technologies in assisted reproduction. So I'll begin with a very brief summary of the existing law on this question. I'll proceed to illustrate my central thesis about the importance of institutional choice by reference to the two main and opposing positions which have been taken on this issue in the existing literature, and then I'll conclude by sketching a very basic and preliminary two-part framework for the sort of comparative institutional analysis which I want to argue here this morning is necessary to support a sound conclusion on whether the constitutional right to procreative liberty ought to extend to new and emerging technologies, to any or all new and emerging technologies in assisted reproduction. So to start with the law, it's relatively easy to sum up in a nutshell the scope of the constitutional right to procreate, to procreative liberty, and the application of that right to new and emerging technologies which facilitate reproduction by infertile couples, by homosexual couples, and which facilitate the selection of genetic traits of offspring by such couples is unclear. There is dicta in several Supreme Court cases stating that the liberty protected by the due process clauses of the Fifth and the 14th Amendments, which apply to the federal and the state governments respectively, extends to intimate personal decisions, such as the choice whether to bear or beget a child. But most of these statements have been made in the context of cases involving a right to use contraception or a right to terminate a pregnancy before viability. A few of them have been made in cases involving rights to control, of parents to control fundamental decisions affecting the rearing of children. But it's quite clear that none of these statements had the use of assisted reproductive technology in mind. And I think it's fair to say that most observers agree that the case law neither compels nor precludes the extension or the application of the constitutional right to procreative liberty to new and emerging technologies in assisted reproduction, although there is certainly some inviting language in the opinions which courts could use as a plausible precedential basis if they were inclined to recognize such a right. So given the indeterminacy, the lack of clarity in the existing case law, commentators addressing this constitutional issue have naturally turned their attention to the normative question, to the question of whether it would be desirable for courts to extend the constitutional right to procreative liberty to the use of some or all assisted reproductive technologies. But the core problem with all of the existing analyses is that they confuse two fundamentally different questions. First, the question of when and whether it would be desirable for reproductive decisions to be protected in an ideal world, and second, the question of when and whether it would be desirable for courts specifically to protect such a right. So these are different questions I will attempt to show and will often have different answers. And we can see this by taking a look at the two leading positions in the existing literature on the constitutionality of regulating various types and uses of assisted reproductive technology. The first, espoused most eloquently and tenaciously by my distinguished co-panelist, Professor Robertson, one might say indefatigably by Professor Robertson, I will call the libertarian approach. And as the name suggests, libertarians tend to favor broad, although not unlimited, constitutional protection for personal decisions connected to procreation, which can be overridden only as necessary to protect a compelling or at least an important state interest. The second approach, of which Sonia Suter's work is representative, we can call communitarian. And again, here, as the name suggests, communitarians attach greater importance to the potential social harms that they see as flowing from, or at least potentially flowing, from unfettered reproductive liberty in the context of assisted reproduction, and less importance to the rights of individuals to do whatever they please in the sphere of procreation without regard to its effects on others. In the context of genetic selection, for example, communitarians have been especially concerned about the effects of assisted reproductive technology on family relationships resulting from the commodification of the reproductive process, the commodification of the resulting children, which they see as a risk of turning reproduction into a kind of quasi-manufacturing process, and also the devaluation of disabled persons whose genes are selected against by prospective parents utilizing assisted reproductive technologies. Now, in light of these concerns, communitarians favor a constitutional principle which Suter calls relational autonomy, which understands reproductive autonomy in terms of what she says are the relationships that define us, and also balances the effects of reproductive decisions on individuals, families, and the community at large. So for all of their differences, and really we can see that the libertarian and the communitarian position are quite at odds about the extent and scope of regulation that ought to be, or probably ought to be permitted in the context of assisted reproductive technology. They share one important feature in common, which is that they are completely silent on the question of institutional choice. Both simply assume that courts should enforce the principles that they, the libertarians, and the communitarians respectively have identified as attractive in the abstract, and take for granted what is not at all obvious, which is that courts will perform well enough relative to other potential decision makers for this to be a sensible course of action, a sensible way for carrying either libertarian or communitarian constitutional values into effect. So we can see this, we can see the necessity of institutional choice to the analysis here by considering what the libertarian position demands of courts. So on one of Professor Robertson's formulations of that position, the class of regulations that courts should subject to heightened scrutiny under the constitutional right to procreative liberty turns on what most people understand as central to reproductive liberty. And another one of his formulations of the rights, courts would be charged with determining which decisions implicate the values and the interests that make reproduction a socially valued activity. And under any formulation of the libertarian perspective, of the libertarian position, courts would be charged with, would be required to determine which state interests are compelling and how likely, as an empirical matter, those interests are to be threatened by the class of regulated activity. So in each of these tasks, it seems obvious that courts will make mistakes. To cite just one example, judges are deliberately insulated from political pressures by virtue of the institutional design of the federal court system, and they also tend to be rather old, to be well educated, to come from elite social classes, making them a curious choice to determine what most people view as central to reproductive liberty, which is, again, in one of Professor Robertson's formulations, the touchstone of the constitutional right. But of course here, the relevant question is a comparative one. The political branches of both the state and the national governments that courts would be charged with reviewing in this context have plenty of shortcomings of their own. They may possess greater resources for discerning popular views on these questions than the courts, but they are also frequently responsive to small and well-organized special interest groups. They may, at an individual level, be similarly competent to judges in resolving philosophical questions, difficult questions of political morality, and they almost certainly have greater psychological and scientific expertise at their disposal, but institutionally their electoral accountability forces them to give strong weight to public views, which are often deeply ignorant and also analytically confused, a problem that might be especially pronounced in an area like assisted reproductive technology, where there are so many science fiction scenarios floating around the public consciousness that really have distorted what actually these technologies actually involve. Now, we can make the same exact point with respect to the communitarian position. It asks courts to enforce a right of relational autonomy, balancing the effects of reproductive decisions on families and the community at large. Here, too, it seems obvious that courts will make mistakes, and for many of the same reasons. But of course, again, the question is a comparative one, whether courts would do worse or better than other institutions from a communitarian perspective by recognizing a judicially enforceable right. An intriguing third possibility here is that both legislative and judicial decision makers would perform so poorly from a communitarian perspective that courts would do better by, even by communitarian standards, by recognizing the kind of broad libertarian right that libertarians have tended to favor. Now, at first blush, this probably seems radically counterintuitive. The commodification and disability rights concerns that communitarians have been most troubled by are classic externalities which an unregulated marketplace in reproductive decision-making would have little incentive to favor in their decision calculus, in its decision calculus. But the political process in the courts, too, are likely to take little account of these interests, while perhaps simultaneously undervaluing the individual interests and family interests, which communitarians also see as important. And if this problem were sufficiently severe, communitarian values might ultimately support a libertarian constitutional right to procreative liberty as a kind of institutional second best, which really underscores the absolutely crucial role that institutional analysis needs to play in our constitutional thinking. If, in fact, communitarian constitutional values might be best realized by a judicially enforceable libertarian right to procreative liberty, we can see that institutional questions of comparative institutional competence can actually drive the appropriate result in constitutional cases quite to the opposite end of the spectrum. I see that I'm now out of time here, so I'd just like to emphasize that as we think about these questions, we keep in mind the error costs associated with any particular institutional decision maker, and also the dynamic effects of assigning constitutional responsibility for these issues to any particular decision maker on the responsibilities and on the performance of other relevant institutional actors, both issues I'm happy to talk more about in the question and answer period. Thank you.
Good morning, and I would also like to thank the Law Review and the faculty here for inviting me. Like she said, I teach right down the road. I'm focusing today on the fact that when I speak to medical professionals, they're excited about what they can do in reproductive technology and the innovative things they can do. Unfortunately, attorneys are not as creative, and so what the courts and the legislature are trying to apply family law principles and laws that applied even before these technologies. So the law hasn't kept up with the technology. And so when I was looking at the program, thinking about what I would present, and the issue said the availability of reproductive technology and the consequences of it, I thought about a lot of consequences and decided to limit it to two, impacting what happens once the technology is available and once it is used, what are the legal consequences of it. So I'm going to talk today about identifying the legal parents of the children, of the child that is conceived using assisted reproduction. And I'm also going to look at protecting the reproductive rights of the dead and the comatose. Because getting into if there's a right to procreate or not procreate, and when somebody dies and their sperm is used to produce a child. Now, there are some cases, and there's some limited legislation dealing with what happens, the rights and the benefits of the children once they're conceived posthumously. But I'm going to look today at preconception issues as to whether or not they should be permitted to extract sperm from dead persons for reproductive use. So in looking at identifying the legal parents, I'm going to look at maternity and I'm going to look at paternity. And I'm also going to highlight a few cases, 3 cases that were recently in the media. And then I'm going to do like a law professor and change the facts and say, hypothetically speaking, had this happened, then the law says this, how would that apply? And one case I'm going to touch on when determining maternity is the Johnson case that was discussed by my colleague. Then when I get into looking at paternity, I'm going to look at the parental rights of the husband of the person that is using assisted reproduction, and also to the sperm donor, and if they have any parental rights to the child. And when I get to posthumous reproduction, I'm going to look at cases where the persons had their sperm removed prior to death, and then they die, and they leave instructions as to what is to happen to the sperm. And those same cases when they die and they don't leave instructions as to what is to happen to the sperm. And then also cases that are coming up quite frequently with men dropping dead, and used to be girlfriends and wives running to have sperm removed. Now parents have got in on that because they want them to live forever, apparently. So I'm going to discuss that. But just starting looking at adjudicating maternity and paternity, why is this important? It's important because the establishment of the parent-child relationship impacts so much with regards to the child, starting as the status of whether or not the child is non-marital or marital. We used to say legitimate, illegitimate. And that's important because for so many things, including especially inheritance, I'm a former probate attorney, so I look through that lens. Still so many things children born out of wedlock have to do in order to have the right to inherit under the intestacy system. Also, it brings into play visitation, it brings into play custody, it brings into play child support. So it's really, really important. And looking at maternity, I know you guys are all familiar with the case where the woman goes to be through in vitros to have the embryos of her husband implanted, and the wrong embryos are implanted in her, and she decides instead to abort the child to act as a surrogate for the other couple, and she's an involuntary surrogate. And she graciously gives up the child. So hypothetically speaking, what if she says that I'm giving birth to the child, I've gestated the child for 9 months, I should and want to keep the child? And so the answer becomes, who's the legal mom in that context? Now we know the biological mom is the person who, the genetic mom, supplied the genetic material to have the child created. And we know that this was a mistake by the fertility clinic. But that's cold comfort for couples who wanted children, and now only one person is going to end up with a child. So the answer is not clear because it depends on what jurisdiction you're in, because there are no statutes, there are a few statutes that talk about surrogates and their parental rights, are very few. And so these cases have been decided by the courts on a case-by-case basis, like Professor Robertson said in California. Johnson case is said intent. The person, because technically we're going to treat her as a gestational surrogate, even if it's involuntarily, because she didn't supply any of the genetic material. She's basically just gestating the child. So in this case here, the intent test that is put forth in California would be difficult to apply because these couples didn't have a contract. They never really had a discussion. But if they're in California, then what do? If they go to another jurisdiction, some jurisdictions say blood wins out. It doesn't matter who's carrying the child, who's giving birth to the child. The legal mother of the child is the person who's supplying the genetic material in order for the child to be created. And in California, actually, there was a dissent in the Johnson case where the dissent rejected the intent test and said it's the best interest of the child. That isn't a bright line rule, is we're going to look at both sets. There are two mothers here, and we're going to see which living situation is in the best interest of the child. And that's the test we're going to apply to determine maternity. And then there's another, the birth or gestational test. The courts that apply that test say we will reject the fact that a woman is just an incubator. It doesn't matter that you don't supply the genetic material. If you gestate a child, there's a bond or there's a connection that is made over 9 months. And so we won't treat you as just a vessel, and we will attribute some type of maternal right. So we will apply that in dealing with maternity. Now, there have been the most recent case in Tennessee. The court went through every different type of test in trying to determine how we identify who's the legal mother of the child, and concluded, well, there's no right answer. What we should do is a factor test. And we should do it on a case-by-case basis, and we should look at this particular situation and just apply the positive aspect of each one of those tests. So right now it's unclear in my hypothetical situation if the woman decides to stand her ground and say, I chose not to abort the child now, and I promise you, not in writing, but I promised I was going to turn the child over to you, but now after 9 months and I've given birth to the child, I don't want to turn the child over. And then we get into court. It is unclear how the outcome, because even in jurisdictions where the court has said we're going to use this test, it will come back, and then also, like he was saying, in New Jersey, they may or not go the way that they did in the Baby M case, because it seems like from a public, they rely on public policy, and as these technologies become more and more acceptable, it gets to be really confusing as to what makes a person a mom. And also, too, the same thing is what makes a person a dad. And the maternity issues have been dealt with more, the paternity more so than maternity, because usually it was easy. The person who gave birth to the child was the mother of the child, but now we've separated gestation out from the actual donating of the genetic material, so that's become more complicated. I'd like to turn to the case of Katie and Robert Ashero. They decided that they wanted to create a child use in vitro, so they go and they create, I think, about 15 embryos, and the fertility clinic finds out that half were fertilized using her husband's sperm, which is what she wanted, but the other half, there was a mix-up at the clinic, and they fertilized it with somebody else's sperm, an anonymous donor sperm. And so what they do is they really try to clean it up really quickly, and so they discard those. And so the couple is suing because they're suing because they're saying they were not informed that they were existed before they disposed of them. And that gets into who owns the genetic material, and I would get to that when I talked about post-human reproduction. So hypothetically speaking, what happens if those embryos are actually implanted? And she doesn't conceive a child using the material, the embryo containing her husband's sperm, but the genetic material of the, now we say sperm donor, the unintentional sperm donor in this case. So the issue becomes, can the husband then walk away with no responsibility? Now we know, because they are married, that we used to say the presumption of paternity, well, it doesn't exist here, right? Because it's clear he's not the father, so that presumption can be easily rebutted through blood tests. And the majority of jurisdictions have statutes dealing with artificial insemination, if you apply the reasoning of those statutes to this type of situation, says that unless the husband consents to his wife being assimilated with donor sperm, he's not the legal father of the child. And also those statutes say that a sperm donor is never the father of the child. So this kid could technically end up being legally fatherless if the husband decides that he's going to walk away, and at this time nobody's going to identify the sperm donor because there are so many reasons why we keep that person anonymous. And lastly, we want to touch briefly on the Aftermom case. As I was watching all the coverage on TV, and everybody started off first, they were saying, yay, and then everybody says, yeah. It turned out, but now I think she has a contract and she has a pretty good deal. And I don't know if you guys watch John and Kate Plus 8 and 18 and counting. You know there's a premium now having a bunch of kids and you know, original type families, you can be, you know, become a celebrity. I mean, Kate went from just Kate to now a celebrity with bodyguards and paparazzi. So what if, and I was watching and nobody was addressing his role, the sperm donor, because her kids all have the same genetic father, right? So he's now donated material for 14 kids, and she's on public assistance, and everybody's saying, well, she was now, but now she has a TV deal. But what if he wants a TV deal, right? So he's a sperm donor, what if, and he's a known sperm donor, and recently in Pennsylvania, the court said that a known sperm donor could be considered the legal father of the child. So what if he comes forward and says, well, everybody in America says she's unfit because she's this, and you know, she's done some really bizarre things on television. And so what if now he says he wants to be recognized as the biological father and have custody, and you can see how this can end up in a real big custody battle. Because even in the jurisdictions where there are statutes, they wouldn't apply to her situation because they only really apply to married couples, and they only apply to artificial insemination, and they usually technically only apply to anonymous sperm donors. So she would not be protected under these statutes that say the sperm donor doesn't have any legal rights. And so it's the possibility if he challenges, the court may say you have a right to visitation. Now, we're not going to unfortunately get to dead people, but just a couple of things about that. There have been cases where doctors are concerned because they have no direction and no guidance. There was a particular case where, and they filed for an emotional story. There was a particular case where a woman came and said, my boyfriend was brought into the emergency room, he's dead, brain dead, and I want his sperm because he promised we would have children together. She shows the love letters where he wrote her, and, you know, I want to be with you forever. So the doctor said, and releases the sperm. You have to do it pretty quickly because, you know, it's only about release the sperm to the girlfriend, she leaves, then the next day the wife shows up. So, so that issue, and so the courts and the legislature haven't given any guidance. And also, too, so two issues to consider. Should we extract and use sperm from dead and comatose men? And once we remove it, who should have the right to request it? Because if you get away from wives and you start getting into girlfriends, what if he's like Tiger Woods and he has a whole lot? And who's entitled? So those are two things to think about.
Thank you so much for that. We have time for about 20 minutes of questions, and we have some mic runners. So, questions? There's one over there, two over there.
This is for Ms. Lewis. I have a question. You got into a scenario where there was a surrogacy, and they, for voluntary or involuntary, but let's say there's a surrogate who, for whatever reason, despite not having any biological relation to the child, chooses to abort. What would be the limit, saying they don't want to carry the child anymore? What would be the legal ramifications of a surrogate saying that they did not wish to carry the pregnancy to term? Has there been any case law on it?
I don't recall any particular cases, but there have been commentaries to say that goes into the right to procreate, and that's been some concern about it, is not just that drastic about abortion, but there's been some discussion about prenatal care. Does she have to eat a certain way? Does she have to exercise a certain way? And it seems to me, in the jurisdictions that want to treat, say, gestation mother versus gestation surrogate, that is out an integrity thing, that even if she aborts, I guess she could be in breach of contract. But I don't think you can force somebody to carry a child to term.
I agree on that. The question would be, if she's received the embryos of another couple and she'd agreed to carry them to term, sure, you can't stop her from terminating the pregnancy, but aren't there some costs that she may owe the couple who entrusted their embryo to her, which costs them a significant amount? I don't know if a court would ever enforce that, but you could see some basis for their claim against her.
Oh, sorry, but you mentioned a case where a woman became a surrogate in an involuntary setting. She decided to give the child after gestation to the biological couple, but what if she just decided she didn't want to do that?
Well, in that case, there was discussion, and they had a settlement outside, and everybody in that process agreed that she could terminate with no problem. Now, getting back to, even if she is in a contract, that gets a lot with the Moore case too, because it depends on, do you own the embryo? The couple that that contracted for surrogate, are they owners of it? And so there's been a whole debate about that as to who owns your genetic material once it's removed from your body.
Is there a second question up here?
Yes, thank you. We're talking about, is it working? Reproductive rights. So how does a dead or comatose person, how do we know what his rights are unless, he set it forth in an affidavit prior thereto?
What is happening is that in the cases, there have been a few cases where they've come into litigation, and the courts have distinguished the cases where the person had the sperm removed prior to death. Like, for example, they were suffering from cancer and they thought chemo would make them sterile. And the court has said there's a presumption that they anticipated death. And so as a consequence, since they anticipated death, then that you can presume that they would have wanted children created using their gametes. But there was a case in Wisconsin recently where the fertility, the sperm banks are now letting them fill out forms. What do you want to do with this sperm in the incident? So I think those cases are easy because usually there's some type of writing, be it a will, like in one case where he willed his sperm to his girlfriend. In the Wisconsin case, he, without the wife's knowledge, said that he wanted the sperm disposed of, and when he died, she went back to try to get it. And the court said we have to honor what he said that he wanted to dispose of. The more difficult cases are when there's no anticipation. And what the families have done is, in the Texas case with the, I think he was 23-year-old was killed in a bar fight, and his mother had his sperm extracted. She said, oh, he always wanted to have children, and she brings in, not his affidavit from people that knew that he had picked out the names possibly for his 3 kids. A lot of guys going over to Afghanistan and Iraq are leaving consent that they would like the sperm extracted. But the comatose patients, you're right, that's a difficult issue, which one I think is going to eventually be a problem, because there was a guy in New York who dropped dead playing video, and they said that, and the girlfriend said, the fiance said she wanted his sperm and they extracted it. So you're right, in those cases when there's no written instruction, the doctors are saying unless somebody else objects, that it's almost like organ donation. Unless somebody objects, they're just going to remove them.
Question in the middle here. Can you?
Recently, there was a case in Louisiana where a judge refused to honor the marriage between a man of African descent and a woman of European descent. Do you consider this to be an attack upon a person's right to reproduce, and if so, do you foresee any more of these attacks by the state in the years ahead?
For anybody?
Yes, anybody.
Being from Louisiana, I would say that's just people being Louisiana. Just being Louisiana, you probably can't anticipate that happening again. So what you're basically saying is the right to marriage tied with the right to procreate. I'm going to defer to my constitutional law people.
Well, the right to marry is involved there, as well as the right to be free of discrimination on the basis of race. So it seems to me that there's no serious question that that would be an unconstitutional action.
The due process right to marry and the equal protection, the 14th Amendment Equal Protection Clause right not to have the state's marriage laws just applied in a discriminatory way on the basis of race would be sufficient, would represent a sufficient constitutional barrier. I think that the right to reproduce wouldn't need to come into play.
Matt?
I'm interested in something Professor Robertson said. It sounds like there might be an inherent conflict in surrogacy agreements where you have, if you're looking at it through a dignity framework, because there's a dignity, say, of homosexual male couple to some right to reproduce at some point in their lives, but there's also the fact that the gestational host, whether she is the egg donor or not, has she's giving birth to the child. So maybe there's a in that agreement, if you're looking at from the dignity to reproduce the gay male couple, and also the dignity of that gestational host because she has essentially reared the child from embryo to life. It seems like there might be some inherent conflict. I wonder if you could comment on that.
Yeah, no, that's exactly, and that's what I was trying to identify with my comments on gestational surrogacy, how one reconciles the two. There's a clear clash between the interest in reproducing of those who need the use of a gestational carrier, an infertile couple or gay males. Their interest in reproducing clashes with the gestational mother's interest in rearing at a later point. How do we reconcile those two? As I said, my own view is that if we've had a free, knowing agreement with a lot of protections, I would favor probably going with a contracting couple, but we'll need to talk about that further here.
We have a couple of questions over this side, and then we'll try to move back to that side.
This question is for anyone on the panel, and it relates to custody of embryos. If a couple, married or otherwise, creates embryos, say they bring one to term, have a child, they split up, and then there have been cases where they have argued over who has the right to the embryos. Does say, for example, the woman have the right to have the embryos implanted and have a child, or does the man have the right to say, no, I don't want you reproducing with those embryos now that we're no longer together?
Well, the courts are pretty clear on this now, that the party who objects to transfer of the embryos subsequent to a breakup will lose, even if there had been a specific agreement in advance where the woman said, look, I'm going to go through IVF, but if we ever break up, I want to be able to use the embryos. And the husband has agreed with that. That's the Massachusetts case, AC versus BBZ. That despite even that agreement, the U.S. courts are coming out in favor of not allowing a transfer of an embryo against the wishes of one of the parties. As I say, it's favoring the one party's interest in not reproducing against the other party's interest in reproducing. I question whether that's the appropriate solution in all cases. Because the person who provided the sperm, wasn't as if the sperm was taken from him in the first place. He gave it with the understanding that he was going to go ahead and reproduce. So in a sense, he's not reproducing against his will. Yes, he is at a later point, but not at the initial provision of the sperm.
And I think that is going to issues going to come up over and over again until we address the issues that were addressed in the Moore case, is sperm property. Because if sperm is property, then in a divorce, we just do the equitable distribution in the marriage. I mean, if the embryos are a property.
Yeah. There's a question.
Professor Robertson, you came closest to addressing this issue, although I'll open it up to the panel as well, and that's the issue of access to the reproductive technologies. And you mentioned perhaps trying to bring the cost down of in vitro fertilization, which brings up the issue of really in the United States, there are only two types of people who have access to reproductive technologies: those who can afford it out of their own pocket, and those who have an insurance carrier who happens to recognize infertility as a covered condition. I was wondering if you can comment on the issue of discretion of the various insurance carriers to recognize whether or not the infertility is a covered condition and therefore provide greater access to those technologies.
Well, the right to procreate, if one accepts that it extends to infertile persons as well, and I have some views on that, is a negative right, does not obligate the state or anyone to pay for that, so it becomes a matter of state policy whether states will require that in health insurance programs by health insurers. But that raises a major issue of access to health care. If reproduction is part of health, as several people in the first panel said, then shouldn't it, part of human flourishing, of normal species behavior, then should that not be covered by any health insurance program? But yet, given the cost, is that something that would be recognized? I note that in the Hillary Clinton health care plan, lo those many years ago, that was one service that was not included. They specifically excluded IVF and infertility treatment from that. So we're left to the kindness of, we're left to state policy and whether insurers want to pay for it. And it's obviously an issue for people who can't pay.
And just a follow-up to that from a public policy perspective, some have argued, is it really necessary when you're living in an overpopulated world, when so many children are in foster care and so many children are in, so basically are we asking people, are we asking insurance companies to pay because people want to reproduce themselves and have little them running around? Because if there's a desire for children, isn't there another way to do it?
Sorry. I'm sorry. I want to. Can I take a minute to just respond to Andy's comments here? Okay. I just want to be sure I get it, because he made some very penetrating comments there, and I just want to respond briefly to them. First, libertarian seems to me to misdescribe or to call what is basically a liberal legalist position, that there's certain fundamental rights that the state can't intrude on without a compelling reason. It seems to me that that's not libertarian. That's a basic liberal rights position. Secondly, I'm interested in how you would handle, which is the sentinel case here, the infertile couple who wants to use in vitro fertilization, that if there were a state law that banned non-coital reproduction, whether you would say that that's something that the court should stay out of because the legislatures are institutionally more able to handle that. And it seems to me that's the case one has to start with. And then if one finds that non-coital reproduction, at least between a couple, is protected, then we have to start looking at all the variations down the line, some of which may be included or not here. But it seemed to me that reproductive liberty should at least cover the case of the infertile couple using their own gametes. And then the final thing about institutional competency, which is a great point to make. I take it then you're siding in the gay marriage cases then with those state courts that have said, this is for the legislature, not the courts. They're more competent than we are to decide a question of basic rights, because that's the same issue here. It's not gay marriage, but it's reproduction, and indeed the reproduction of gays. Aren't courts situated to at least make some decisions about basic human rights?
Coan, do you want to?
I would like to respond. First, and I'll just take the points in order. I didn't mean, and I hope there wasn't any confusion on this point, by using the term libertarian to describe your position to identify you with ideological libertarians. I meant to use the term in a sort of colloquial sense, just to indicate your support, if I understand you correctly, for a fairly broad presumptive right to procreative liberty, extending to most, if not all, uses of assisted reproductive technology.
But not to most or all. It's simply to the infertile. Let's focus on the case of the coitally infertile and see what we say about them. Whether it extends beyond that is another matter.
Okay. Well, we can talk about those particulars later. But you know, the second point is that even if we accept the basic liberal legalist position that there are some rights that the state cannot intrude upon, it remains an open question which institution we want to entrust the responsibility of deciding, of drawing the limits, of delineating the limits of those rights, and also determining the circumstances under which a particular countervailing interest is sufficiently compelling to override those rights, which is part of the core liberal legalist position on rights. And finally, as to the gay marriage question, I want to be clear. You know, analysis or emphasis on institutional competence is often associated with a strong preference for the legislative process. I don't mean to put a thumb on the scale in that way at all. I just mean to suggest that in each of these cases, the institutional question is central. In many cases, I think it's a very close call. The legislatures, the legislative process and the administrative process, the political branches generally, are deeply flawed in many ways, and we should be very suspicious of their ability to handle many of these questions. But we should also be very suspicious of the court's ability to handle these questions. In the words of my Wisconsin colleague Neil Commissar, whom you know, we're always dealing with choices between deeply imperfect alternatives. The question is, in most of these cases, going to be which is the least bad or the least untrustworthy. And it's certainly in the gay marriage case, I would not in any way want to come down on the side of the legislatures.
Good, that's a very helpful clarification.
Well, if the law review editors would crave my indulgence for an extra 5 minutes because we started a few minutes late, I think I saw 2 questions on this side. If we could ask both the questions together and then the panellists could respond, we could save some time and then finish up. So.
Well, mine is addressed to all 3 of you. Nothing has been said about nationality. What would happen were a person to actually be a surrogate parent, have no biological relationship to either the egg or the sperm? For example, a young woman would be of a different nationality. She'd be over here doing whatever, but she decided that she needed some money. So no contract, but an agreement. And she goes back to visit her parents in another country. And the child ends up being born in that country. Is that child an American, since the person who bears them is not an American? They are not born in America. What determines? Does the sperm and the egg determine, or does the surrogate parent?
Could we just ask the second question, then we'll answer them both together? No? Okay, well, we'll just answer that question.
Well, I think that's why I say it's so important to adjudicate maternity and paternity, because it relates to those particular issues. And so I think that would be resolved depending on the test that is applied in the jurisdiction, because the courts that say intent, it doesn't matter what her nationality is, they get the kid, and if they get, because the way these agreements are set up is they get the right to adopt.
But what is the jurisdiction of the court? Is the court, let's say it's born in Poland, is the court a Polish court, or is it an American court because of the nature?
But the jurisdiction usually is probably filed in the, oh, you say no contract, just a verbal agreement?
No, just verbal.
Wow.
Well, even if there's a written or verbal, I don't think matters.
Yeah, I don't think it messes.
Well, but it's worth separating the question of citizenship and the question of custody, right? Those will be governed by separate legal regimes, and but both of which I have next to no knowledge about. So.
No, but I think you're right, but I think that it goes a long way if the court says this is not even custody when they're talking about determining who's the legal mother. It goes beyond custody. It says you are the legal mother of the child. And I would say that it doesn't matter whether it was, you're saying what, conflicts of jurisdictions?
Yeah.
Except, but wouldn't the baby be fertilized with the sperm of an American citizen?
Yeah, but
so
citizenship doesn't follow genetics.
Right, it does.
Follows place of birth, of maternity. Reproductive tourism is a growing facet of these incidents. Often, a lot of Canadians, I see the Canadian flag here, a lot of Canadians come to the U.S. for egg donation, paid egg donation because they can't get it in Canada, but there are American couples who go to India because the surrogacy rates are cheaper there, and there would have to be, I think, a relinquishment of the mother's rights to be clear in India, adoption by the parents there in India, and then arranging for
but I think
U.S. citizenship there as a foreign adoption would be the safest way. But there are a lot of questions there.
But her question is wonderful, because I think she's saying, what if the person decides not to honor the agreement?
Well,
so
that's
yeah.
Then.
Well, I think we're not going to solve that brilliant question before lunch. But before we break, I'm supposed to let you know, if I have this correct, that there will be boxed lunches available across the hall for the next hour or so, or not, hopefully. There will be, there may not be quite now. And we're going to reconvene here at 1 o'clock for the keynote, and will you join